Let's say directed this matter to be listed on the 26th and had directed us to appoint the directors in accordance with the directions of the NCLT to show our benefits. Let's we have appointed the directors, but the long we're asking for the date 15th or 16th month for listing.
Was it not listed on that?
No, the bench didn't accept it. Please, 15th or 16th considers.
Why don't you file a mention amendment? Normally we don't accept without a mention amendment.
Well, let's
file a mention amendment.
With the notice permission and mention one item, it was listed on 2nd September, madam.
Same thing, file a mention amendment.
One second. It was listed on 2nd September, madam, item number 63. Up to 4 o'clock, I think item 28 was taken, but somebody circulated a letter. It has circulated a letter. It is a medical admission matter. Now,
unless you file an objection letter, wherever there's an objection letter, we keep the matter aside.
Up to 4 o'clock,
you must have received a copy of the adjournment letter.
Court time, it was only 27. My item was 63. So in 63,
once there are letters for adjournment and there is no objection, then we grant the adjournment so that other matters can at least move on.
It is medical admission matter.
Whatever it is, you
now
file an objection letter.
Other students have already taken admission matter. Now it is 18th November. By that time, especially
you ought to have filed an objection letter. There was one matter in which there was an objection letter. We did not grant it.
Item number 63. My difficulty.
Whatever it is, you need to file an objection letter once there is a letter for adjournment. Procedure that is followed. Better than we are.
Upon mentioning, I got my matter listed. Now, difficulty is the counseling will be
you
over.
ought to have at least stayed back because the week before that also I granted adjournments before rising. So you ought to have at least been aware of the procedure which is followed in this court.
Only
be mindful.
Last item, someone was going on. Only item 27. It is item 63.
File another letter again. Another letter for mentioning. Give it to the other side.
Lordship, I am making a request, Lordship. I know it's not very appropriate, but I just want your Lordship to go. Lordship, there was a matter before your Lordship, regular matter before your Lordships yesterday, 105.
Which did not reach.
Which did not reach, and we thought we were not aware of the holiday today. I mean, tomorrow, Friday holiday. We thought the matter is going to come today.
So the calendar, if you don't even bother to look at the calendar to know which day is a working day,
anyway,
you don't keep track of festivals, then you want to come.
Then, Lordship, what I want to say is, Lordship, this matter, the counsel is in personal difficulty. I have to go for treatment. I'm not well. So let this matter come
next week.
Lordship, next week it will not be possible for us. Week to
file a letter for adjournment.
File a letter for adjournment.
They don't take letters.
They don't take letters.
They don't take letters. Make a mention. Ask one of your colleagues to make a mention.
Well, Lordship, please allow it.
Ask your colleague
to
make a mention. We will remember. Which item is this?
This was 105.
What is the name of the party?
Daljit Rai Oberoi.
Very good.
Versus financial.
Very
Applies, Lordship.
Item 1.
Item 1. Anticipatory bail in a 2022 FIR at the station.
I'll just pull up.
How many anticipatory bails will you file? First anticipatory bail rejected by the High Court on 11th October 23. Then you just keep quiet, again file another anticipatory bail
like this
rejected on
it's like
21st February 25.
Yes, Lord, absolutely all. There's only one thing, Lord, what I've submitted. There's one.
We don't even know what happened in the interregnum. 82 proceedings might have been initiated.
No. What happened was, Lord, the earlier.
In any event, Counsel, we will not grant anticipatory bail for FIR of 2022.
The Lordship, two things, Lord. It's a high court.
Whatever it is, we will not grant
I resigned
after 3 years.
I resigned. Lordship should appreciate, Lord. Lordship would appreciate.
However, we do not.
Lordship appreciate. I resigned from this. Because earlier I was not granted.
Especially questions accordingly.
Lordship,
you don't understand what we have told you. We can't.
Lordship, what I'm submitting is
on merits. We are not going to go into the merits. We already told you it's a FIR anticipatory bail in 25 out of question.
Subsequent event, Lord.
Whatever is the subsequent.
I resigned from job, Lord. I resigned.
Next matter, please.
Resigned from job, Lord.
Next matter.
And all that. That's why.
Next matter, there is a pending SLP, so we'll tag it with that.
Lordship may formally
notice and tag with the office report mentions.
Grateful, Lordship.
3. Making Lordship. Petitioner here not claimant and are seeking for enhancement of compensation.
939 days delay here. Before the High Court, 652 days delay. So you keep waking up at your own convenience to ask for a little more. High Court has already enhanced the
My
compensation.
lordship, in fact, the difficulty has.
Look at your control delay petition. No reasons.
My lordship, my difficulty was the amount.
Page 51. Please look at your control delay.
The amounts were only released at 24, your lordship. So that's the reason.
You can't just keep waking up at your own convenience and say that I don't know anything about legal procedures. You went before the High Court, got it enhanced. Now before the Supreme Court, you are legally ignorant. Not
Their judgments of this honorable.
We are not inclined to condone the inordinate delay of 939 days in the filing of this special leave petition, coupled with 112 days in the refiling of the petition. The condoned delay petition is accordingly dismissed in consequence the special leave petition to all.
My lordships are generally liberal as far as land acquisition
Not
matters.
when you wake up at your own. Before the High Court also 652 days delay.
My lordship,
So every stage you will come with delay and say, I want a little more.
it's a matter of. Please, lordship.
Sorry.
May lordship. May please,
Item
lordship.
4.
Petition herein are defendants, your lordship.
You are claiming under this unregistered gift deed,
Gift deed, your lordship.
which is not even allowed to be marked in evidence. That order has become final.
Please, your lordship.
So that gift deed is out.
Gift deed is
What
out.
remains in the plea?
Well, it's been more than 70 years that I've been in possession.
What remains? You have no basis now. Even your unregistered gift deed is excluded.
My lordship, there is no inquiry. In fact, the cost of purchase.
They get condoned. In this will condone the delay.
Well, even as I
However,
look at this, I'm not on the merits, your lordship. So I'm on the.
We are on the merits. There's nothing there. There's not even
That's the mixed profit.
leave of
No inquiry.
you don't even have a toehold.
My lordship, it's.
There's nothing at all to support your claim.
My lordship, there's no
They
denying
have a
fact.
registered sale.
There's no denying fact that I continue to be in possession. It's been more than 70. It's been more than 70 years that I continue to.
Election to deliver position.
My lordship, now the difficulty as of now.
Over, Mr. Nooli, sorry.
My lordship, I'm not at the point.
Next matter.
In fact, no inquiry was conducted.
Next matter, you don't have anything at all.
Item 5, consideration to VC.
Yes.
My lords, in this case, my lord, the High Court has dismissed the petition. Condoned the-
1,009 days delay in refiling.
in refiling, my lord. Appeal
Refiling.
was filed in time.
Filing, high courts, if it is in excess of 1 year, they are entitled to look into it. A litigant is entitled to think that the litigation has stopped after the passage of some time. You can't just wake up after 1,409 days and say, I'm going to refile it now. And even on merits, you don't seem to have a case. What is it that you secured an ex parte judgment in a declaratory suit, which is the trial court does not even go into the issue that the High Court directed it to look into. And then you ask for a patta. This patta is a different limb of the litigation. It has nothing to do with your ex parte decree.
That we will argue on merit before the High Court.
Sorry,
My lord, due to death of the counsel, the counsel died, my lord. The counsel died of COVID-19.
Especially questions according to dismiss. Dismiss counsel.
Will the counsel appearing to VC?
The application, if you look at the order, we have not dismissed it only on the ground of default. It is on the ground that the matter is fairly covered. And we had already dismissed another SLP relating to the very same order. What remains?
Lordship, the challenge was on the basis of the
Covered video protocol, which was followed
proviso.
by the High Court, and on the basis of which the SLP filed against the very same order by another party has already been dismissed. What remains then? Sorry, Counsel. If I know.
Lordship, even in the impugned order of the High Court, it was that we could file a representation within 3 weeks, Lordship. Now, let me be allowed to file a representation.
There was no representation on behalf of the petitioner, but also on the ground that another special petition arising out of the very same order was dismissed. The miscellaneous application of accordingly dismissed.
Detailed refiling. The court notices lenient approach to be taken but unless.
The delay is 210 days and 213 days, 2 matters.
One matter,
You you e-file it on 18 July 24, the hard copy is not filed. You say it is lost in transit, where it was coming by walk from Hyderabad to Chennai. Bullock cart, train, flight, how is it lost? How did you find it again? After 210 days delay. Defects are pointed out on 19 July, 7 days, very well, 7 days is not mandatory. You can't wake up after 210 days. Sorry. Delayed here, we will condone. Refile. Delayed condone, however, we find ground and reason to declare as by the National Company Law and Tribunal, get me this accordingly. That is adjourned on the ground of ill health of the learned advocate on record for the state of Uttar Pradesh. List on 18, 17.
Right.
9. 9. 9. What is wrong with the order? Limitation is not an issue unless it is so blatant for a 11 court to take notice. You have to raise it before the arbitrator. That is a question.
For sure, why I'm making submissions. But so far the limitation aspect is concerned, Section 3 of the Limitation Act says that.
Raise it before the arbitrator. It is not a. Ordinarily, limitation is a mixed question of law and fact. Unless the facts are so blatant that the judgments of this court also permit a 11 court to reject the 11 application if it is a case of that nature. This is not a case of that nature.
It is that,
So, no, we're not persuaded to agree with you on that. We've already gone through it. We find no good grounded basis with the privilege equal that passed by the High Court, especially if it's according to this.
And with my Lord's permission, unless IOCL wants to hang somebody, I happen to be the person who's now the dealer.
Your letter of indemnity says that you did charge
No, my Lord,
on
not
5th
charge.
June.
No, my Lord, that's not charge.
Please look at your letter of indemnity, please.
The relevant page 33, that's where the language is. This is the typed copy. The paragraph
Please look at not 33, 32, 3A.
3A.
Proprietor of the newly constituted
Have
dealership,
taken over the
Labanita Malakar, has
liability.
taken over the assets and liabilities, newly constituted, shall continue to operate the
That
dealership.
is simply to say,
Termination letter indicates irregularities after you took over.
my Lord,
Therefore,
the
the
name till date,
arbitration clause
even
applies.
the-
Not
my Lord,
a question of
just-
visiting the past
my Lord,
sins of your predecessor upon him.
my Lord, just 10 seconds. This is a standard form
High
contract.
Court is not close to the remedy.
I bow before my lords. I am bound to fail. I am bound to fail in arbitration.
Not necessary.
The person,
You can't look at the judgments. After that Amritsar gas service, there is another judgment of this court
I bow.
with regard to the scope of interference in such an arbitration.
I bow before
You
my
need
lords.
to do your homework.
Fact of the
You
matter
need
is,
to do your homework and advance your case.
my lords,
before the arbitration.
this is a
We are not
standard
going
form
to interfere.
contract.
We are not going to interfere.
In that case, my lords, if I may request my lords to let the agency continue
No.
while we arbitrate.
Section
We
9,
have the-
Section 17, whatever you wish to avail of, to avail. There is a question of us granting you relief.
Obliged.
We find no good ground and reason to interfere with the impugn judgment passed by the High Court, especially if it's according to business.
Obliged.
There's delayed basis. No, 9 or 10 is it? 2 days delay.
2 days delay. Yes, 2 days.
Lordship, this is a matter where,
Against an adjournment order.
Lordship, I'm dead on papers. I'm proving since 2008 that I'm alive.
We are not going to arrange the board of the High Court now.
Lordship,
How many
since-
cases have you
Lordship,
filed?
since
What is the
2000
single miscellaneous,
Lordship,
miscellaneous single? Then you have a writ petition.
it's a writ C, Your Lordship.
There's a separate miscellaneous single and a separate writ C, is it?
No, Your Lordship.
There-
Now it has
both
been merged
the
into writ C, writ petition C.
Whatever you.
Lordship,
need to-
since 2008, I'm proving that I am alive, Lordship, my right to life is totally violated, Lordship.
Not
I'm at
against,
mercy of
you
my lord.
don't even file copies of the Tehsildar's order 10th July 2019, the dismissal of your revision. We
Lordship,
don't even
I-
know
I-
on what
I-
ground.
Lordship,
We've already
I
said
mainly
this
agree.
again and again. When you do this selective
My
filing,
lords, I am mainly
when
agreed
you do
because
this
of the-
selective filing, you take the consequences of it.
My lords, I am.
If you do not disclose the orders and the material which is adverse to your interest, and then when we put it to you, then you offer very
My lords,
kindly
I am before the
to file it thereafter.
for a very limited
We are not
period.
willing to accept.
I could be
Sorry.
decided.
You find no good ground.
Only a single-
The especially petition.
My lord, a small observation that High Court may decide for early listing. Lordship, I have filed 8 early listing application, Lordship.
File one more.
The
then.
right to life is
Move
not
the
violated.
court, do whatever you want to. Yes.
Lordship, a small
Well,
observation with
no.
respect to your Lordship. Early disposal of the
Sorry.
case pending before the High Court, your Lordship.
No. Well, next matter.
I am grateful.
Item 12.1 for representation for the petition. List on 13%. 13 connected with that. Then no one online also. Nobody is there. Someone is there. In 12 and 13. Hello. Counsel, are you at 12?
Please, Your Lordship, number 12 and 13.
Yes.
Your Lordship, there were 3 petitions filed. Actually, 2 are listed and 1 is still left, my lord. So, Your Lordship, may just adjourn for 1 week. I'll check with the registry and get that also listed along with this.
There's something else also. There's another matter listed. When
Your
you
Lordship,
go together,
Your
when
Lordship.
we go together, is there another matter?
Yes, my lord, against the same order, my lord, 3 connected SLPs were filed. Only 2 are listed, 1 is left, my lord. I'll check with the registry and get it listed, my lord.
Because we are inclined to dismiss these also.
Yes, my lord.
You have already filed appeals against the consolidation officer's orders dated 5th and 6th June 2024. After that, you amend your prayer in the writ petition to challenge the very same orders. The High Court is justified in saying you follow up in your appeals. Why should we entertain the writ petition? You can't write this at the same time.
My lord, by arguing counsel also is not available today, my lord. I was just instructed to request your lordship for the same, my lord. After 1 week, my lord, I get that also listed.
6 in adjournment on the ground that we are arguing counsel is not available. Let's stand. 10th November. Both of us.
In 12.
Please, Your Lordship.
Highly obliged, your lordship.
14.
14.
Please, Your Lordship. But here, the writ jurisdiction has been used to
Secure a decree. You
Not
secure a
me.
decree.
not me, the other side. Secures a decree, my second appeal is pending.
High Court has
Second appeal is pending, and Lord, please see the judgment.
Kindly have page
See the judgment.
It's on the basis of a decree, is it not? How do you file a writ petition?
see page 77. There's
And
nothing to
you,
execute.
according to the suit judgment, you are still liable to pay 54,539.
No,
Kindly have page
These
77.
are not issues that can be looked into in a writ petition.
the
If you secure a decree, there is a
Correct,
procedure prescribed to
the decree says,
Sorry.
that the demand is set aside. The first appeal
Not
of
a writ petition.
second appeal is
Writ
defective.
petition ought not to have been entertained
Well,
to
kindly see
execute a
page-
decree to begin with.
There's no execution. Kindly see page 77 for a moment.
What is the
There's a
basis
wrong
for your writ petition?
The basis is this.
Please tell us what is the basis for your writ petition?
This
It
is
is
the-
that decree.
No.
You didn't mention the decree at all in the writ petition.
That's what I see. This
Did you mention the decree in the writ petition? Yes or no?
A prayer of mandibus, because
Did you mention the decree in the writ petition?
I did,
Then that is
I
not.
did. I
You
did.
should notice. Return long.
For a moment, just have page 77.
November.
That's the decree.
Learned Counsel.
Nothing to
Give
execute.
your name, please. Mr. So-and-so, Learned Counsel.
Please,
Waives and accepts notice on behalf of which respondent, all of them?
all.
On behalf of the respondents. We are of the opinion that the High Court ought not to have entertained a writ petition under Article 226 of the Constitution. Simultaneously, we are of the opinion.
But should I give the good judgment?
Right.
This
Not
is
to have executed a writ petition for execution of a civil court's decree, judgment and decree. We shall accordingly be stay of operation of the equivalent judgment dated 16/5/2025.
I must point out for your
You can file your reply.
The operative part is incorrect. The
File your reply.
is incorrect. All I'm pointing out is this. There was no direction to hand over. All I'm pointing out
File your
is
reply.
very well.
Please, Lord.
In this case, the suit under 37.
It's an unregistered partnership.
In fact,
And one partner is suing the other partner under order 37.
suit was not for the by the partnership firm. Can you see?
Section 6.
Sorry, Counsel.
Well, can you see in this case
The section 69 bar is a hurdle that you can't get.
So far 69, I satisfy on that.
Sorry.
This is not a case by a firm or a partner.
Partners also interstate cannot give each other license. It's an unregistered
By
partner.
a holder of the.
We find no good ground and reason to prepare especially petitions.
There are good reasons explained by the trial court, Millard.
Sorry.
And this suit was by the holder of the check, Millard, not by the partner.
Next matter.
16.
Please,
Delay in filing.
seeking an adjournment, my lord, we have to put an additional document on record. It's
Not
very
necessary. You'll have to first satisfy us. To begin with, you made wrong statements, which is of course the norm in the Supreme Court. But you don't have to join that bandwagon. Is it not?
Lord, I was instructed.
Please look at your application for condonation of delay. Page 138,
Yes, sir.
para 3. Please read it out. Read it out, Counsel, aloud, not to yourself. You're not able to find page
However,
138.
due to the ongoing vacations of this honorable court, the civil appeal could not be filed by 30/6/2025 and the
13/6, not 20.
13/6, and the same is being filed on the first full working days of this honorable court on 15/7.
It was not filed on 15/7. And that apart, you ought to have at least verified with the registry whether it will support you when you make this kind of statement. I verified with the registry, and even during the partial working days, all filing is entertained, not just the vacation court, the partial working court filing. So you could have filed it during the vacation. So first wrong statement is that you could not have filed it during the partial working days. Then you say that you filed it on 15th July 2025. Filed on 7th August 2025. Your, what is it called? Your checklist. Your checklist is dated 2nd August 2025. The affidavit is dated 2nd August 2025. You filed it on 7th August 2025. So on the ground of projection of wrong facts, we won't call them lies, but incorrect facts, we will not entertain this. In any event, it is barred by delay. Section 62, even a day's delay, barred. There's no question. There's nothing you can do to get over it. On the face of it, it is barred.
Arvind Consul is not here, my lord.
You'll have to take the burden. We are not going to just burden the list because you want to file a document or get somebody else. Whoever it is, they can't get over this. So there's no question. On the face of it, this appeal is clearly barred. Appeal filed under section 62 of the Insolvency and Bankruptcy Code 2016 is clearly barred by time. The appeal is accordingly dismissed on short plan. The concurrent petition is dismissed. In consequence, the appeal is also dismissed. Contempt was not entertained. But in the contempt, we made an observation. There is a contempt order.
See that order at page 51.
So we will make an observation. Perhaps it will be in the.
Kindly see my predicament.
We understand what it's being
March
adjourned.
24. March 24.
Please hear the order.
Can I place a
And
submission?
this court did not entertain contempt proceedings sought to be initiated by the applicant and rejected the same on 25/11/2025. We are not inclined to entertain this application. However, we would request the National Consumer Disputes Redress Commission.
State Commission.
Oh, State Commission. The State Commission, Panchkula, to be mindful of the observation made in the aforestated order dated 25/11/2024.
So also the Lordship's order of March.
Proceed to
March 24, 19th March.
Yes,
Parent
I-
order. Sorry, Lord.
The parent order at page 28.
28.
And that is what I want the lordships to please consider. That's the parent order of your lordship's
Yes.
court.
With regard to the refund of the money.
Yes, Lord, and your lordship's order in the last directions, the adjusted amount shall be remitted to the buyer within a period of 6 months from today. That's March of 24.
However, we would request the State Commission Particular to be mindful for the observations made in the administrative order 25/11/2025 and proceed to decide.
The matter expeditiously, keeping in mind the fact that the petitioners are elderly. Full stop. We
I lost
are
my wife.
constrained to make
is
this
true.
observation, given
One
the
of the
fact
petitioners.
that the operative portion of the main order dated 19/3/2024 passed by this court in the, it's been numbered.
Which?
This appeal must be numbered, civil appeal numbers.
Yes, sir.
43W-4389 of 2024 require the judgment letter to remit the amounts due and payable to the buyers
Within 6
from the applicant's hearing within a period of 6 months from that date.
Lord, would your lordship also further consider, Lord, my predicament, Lord, I lost my wife in June 25. One of the
You
petitioners.
need to follow the procedure.
Lord, but Lord, if your lordships could consider,
We are not going to end.
Lord, kindly consider one,
Once we open this door, there is no end.
Lord, within a period of, let him do it within a period.
We reiterated the request. Let us
Yes.
see what they do.
Lord, if your lordship say
Yes.
that within a period of.
We would therefore reiterate the request made in the earlier order and the State and Consumer Dispute Redressal Commission shall endeavor to dispose of the execution petition as expeditiously as possible and preferably within
3 months, Lord. It's now 1.5
4
years
months.
now. 4 months.
4 months from.
Very grateful. Lord. 18, very grateful.
18 letters that current counsel for the petition seeks an adjournment on the ground that he is awaiting the judgment in another specially petition which would have a bearing on this case. Matter is accordingly adjourned, list on 24th November.
19. Yes. My lords, there is no prima facie
What's
case.
the case for quashing though? There are enough allegations made against the husband, against the mother.
It was only counter blast against me, my lords, I had made.
Because the dates by themselves are not enough. She may have been hopeful that you would take her back. Once you file the
My lords, when I issued,
then she knows that
my lords, when I issued her a notice.
there's no chance.
After that.
So she comes out with her
When she
490.
kept the matrimonial household.
Not a case for quashing comes. Yeah, delay condo, however, we are not inclined to
Please.
interfere with the judgment passed by the High Court. The specially petitions 55 also.
Yes.
55 also. 55 and 55.1. Especially petitions are according to this.
20. Your Honor, I am requesting for and pass over this.
20.
Yes.
Praise the Lordships, I'm appearing in 21. My Lord, this is an SLP arising out of the quashing of my FIR. My Lord, I submit with utmost respect, Honorable High Court did not consider that there is an element of criminality which is permeating throughout the transaction which is conducted by the respondents.
Your criminal case is based on those two agreements, and there is already a suit pending.
My Lord, the suit is there. My Lord, the suit comes thereafter. My Lord,
Unless the suit
My Lord, the first agreement.
ends in a dismissal upholding those agreements, there's nothing.
My Lord, the first
The
agreement.
substratum of your criminal case is gone.
They take the money, they come
The
back.
substratum of your criminal proceedings is now under challenge. Why should it be allowed?
My Lord, the investigation was still pending. My Lord,
Sorry,
it will be allowed to go into.
Charge sheet was already filed. Where is the?
My Lord, your Lordship, charge sheet.
Charge sheet was filed on 19th.
My Lord, the charge sheet kept the investigation pending because
Sorry, guys, we are not
respondents never
inclined.
cooperated.
They cannot. However, we find no good.
My Lord, may observe that in crisis, your Lordships have also held that it's just a civil transaction, not.
Especially petition according to this.
I'm obliged.
22 and 49.
There's a connected matter.
Yes, sir.
If you notice the
coming
fact
up
that.
on, it's coming up on 27th of October, my lord.
Once the date is given in the.
Wait, please.
23.
Wait, please.
23.
Well, the order of addition.
You are the custodians of the record.
Yes, just kindly appreciate, my lords. The reasoning given by the addition is that he had just remitted the matter back only on 3 grounds, my lords. First, that there was no reasoning given while issuing summons. That's the first ground. Second, my lords, the most important exhibit C2 and C3. Now, C2
case for
just observation. No, not a. My lords, just kindly appreciate the.
You challenge the summoning order.
I challenge the summoning order only, my lords. I'm not gone for questioning.
You obviously need to face the trial. The summoning order is set aside.
My lords, just kindly.
Where is the question?
Just kindly just see. This is exhibit C2.
You are the custodian of the record. There is one ACR which says nothing.
No, that's
the other ACR says
please,
integrity doubtful. There are 2 ACRs.
Please have a look at 254. Please have a look at 254. 254.
Are there no?
Just have a look at 2 ACR. That was an unsigned document which he is saying. The document which is signed, please have a look at 254. I'll leave it after that.
254?
Yes, para 13. Now, C2 is the first he is referring to. It is pertinent to mention here that exhibit C2 has not been attested by any authority, whereas exhibit C3 has been attested by deputy. So this is exhibit C3. Which
the ACRs were missing. He had to apply for them.
This
Thereafter, these 2 come to light. You are the custodian of the records. We don't know which one is tampered with.
No, this C2 he is getting it. This observation of the High Court. Just have at least this observation.
Just you would leave it after that.
No, just one line. Just have a look at page 6.
After you read out the paragraph, you would leave it.
Just have a look at page 6. That observation I am going to be convicted. Please have a look at the observation at page 6. Please have a look at the observation.
That is the question.
Yes. No vendor. No vendor. No. Just 3 lines, my lords. Yes. Paragraph 17. No wonder it cannot be denied. Respondent 2 and 2 to 4 are the custodian of records, and there has been tampering with them. If this observation I am going to be convicted, at least they will independently be let the trial. This observation at least can be.
That can only be proved.
No, I have read the whole truth. Just at least the observation. Kindly appreciate. With the trial court with this trial court, this observation from the High Court.
However, we
very grateful.
Your question.
24.
24.
Your Lordships, I am appearing. I'm the proxy counsel for the petitioner, Your Lordship. The senior advocate is in some difficulty because of illness, Your Lordship. I'm requesting for a date on Monday, Your Lordship. Even the
adjournment, leave the date to us.
Your Lordship, the AOR's father is also because both
6 days delay in filing, and then
Your Lordships, there are 2. Your Lordships may just allow the senior advocate to submit the case on Monday, Your Lordship, because it is a slightly important matter, Your Lordship. I'll just request if the
ground that the learned arguing counsel is unwell today. List on 27th October.
Oblige.
25. Question. Well, the specially petitions referred by the co-accused was dismissal. The order is the last page of the paper book.
What remains?
It's the last page of the paper. My lord, happy?
Yes.
He was A1, I am A3 minus A2 was not prepared. Lordship, delay may be controlled.
Delay controlled. However, we find no good ground and reason to prepare. That's why the special petitions accordingly dismissed.
I'm over. 26.
26 same order SLP is pending. One is here. Notice tagged with SLP numbers. Delay control. No, these matters where there are exemption applications for filing OT. So those will be asked for 10 legal jobs. Those who are not. One line at least exemption can be granted.
Deeply.
27.
My lords, I appear in this matter. My lords may see the trial, the High Court, my lords, the
Kothari will be issuing notices.
Grateful, my lords. Much obliged.
Returnable on 10 November. Service shall be effective by all modes.
Grateful.
My lord, in this matter, there is gross My.
Yes, 28.
Yes, but in item 28, there is gross suppression by the.
When did the state become a partner to begin with?
She was never a partner, and in fact, in
Then
2016.
why would her signature be on the
That
check?
is, my lord, that is precisely the problem. She may have been a signatory to their bank account. Her husband was a partner later. Her brother-in-law was a partner.
The check is issued in the name of the partnership firm.
Yes,
You
it
don't have a
seems.
copy of the check though.
No, my lord,
That's
there is no
2017 check.
copy of the check, but it's she
Does
left.
it have a stamp of the partnership firm?
I haven't seen that either.
That's
I have not
important,
seen
is it not?
And in fact, it's a time-bar debt as well. But that is.
We know whether she signed
My lord,
this, she's
absolutely.
supposed to have signed this on behalf of
Absolutely
the firm. Because he exits the firm in 2016.
Yes.
Check is of 2017. There's no clarity as to whether you're a partner, if at all you became a partner.
It's 2024 according to him. That's how he puts it this late. It's a completely time-bar debt. That's the first
And
point.
you are in the habit of
I left a
laying
blank
around
because he
signed checks.
My lord, I was the wife of one of the partners. Unfortunately, because it was a family business, I left it with my husband.
Unless you show us the check, there's no possibility of even.
Maybe bring the check then, my lords. We'll
File a copy of
put it, my lords.
Copy of the check in question shall be filed by the next date of hearing. How much time will be required?
My lord, 1 week.
Yes, strong.
In fact, the bank account was closed 2 years
20
ago.
seconds.
Yes, much obliged.
29.
Mail SLP is at item number 39, in which I have moved an application.
Matters. To begin with, the way you have filed these SLPs is highly irregular. One person files against review order, one person files against the main order. Then we say, what is this? Then you again file separate petitions.
Sorry, I have now filed it. That's at
But
39.
leaving aside that aspect, these irregularities in filing,
Sorry.
your application, which is the subject matter now of these two orders, the main dismissal order as well as the review order, your application was to recall this 23rd August 2018 order.
Yes.
Is that right? 23rd August 2018 order, you wanted it recalled after that order had already been acted upon. And an order is issued pursuant to that order, rejecting your request to release the land from acquisition. Your cause of action now would be in relation to that later order. Where is the question of you're trying to remove the foundation now after that 2018 order has already been acted upon?
Your Worship, in fact, I have also filed a independent.
You don't understand what you were trying to do there.
I'm sorry, may I just say it, Your Worship? I have also filed an independent writ petition.
What is the point of this exercise?
Your Worship, may I submit? I have also filed an independent writ petition
Against the
challenging that
31st May 22 order.
Yes.
Then we pursue that then. Why should we entertain against
My
this
only
order?
problem is, Your Worship, now this order, once that case is taken
This
up.
23rd August 2018 order is actually in your favor because it directed the government to reconsider your application in the light of the fact that R3 did not want your land.
That is true. But now
Then this order you wanted recalled.
No, reason being, thereafter the state government heard the matter
And rejected your request, which you challenged now.
Which I have challenged.
Then where is the question?
So all I'm praying is, this order should not come in my way.
How will it come in the way?
Your Worship, my problem
Whatever active imagination you have.
Your Worship, page 92. Page 92 may be seen, Your Worship. Just 4 lines on page 92.
90?
That is my written submission before the High Court in this application, Your Worship.
What did you say?
Your Worship, just see note after the cast title note. Main civil writ petition number so and so was fixed on so and so, has been drawn for 15th of May 2024, challenging order dated. That's the. These CMs are required to be heard along with said writ petition. My only problem is, Your Worship, the dismissal of this CM
will not affect the writ petition at all. How will it affect it? It's an independent cause of action.
That's the apprehension of the. All I'm saying is.
These two 29, 29.1 goes with
39, Your Worship.
39. 39. and 39.1. You are appearing in those items also?
Yes, sir.
We find no good ground and basis to differ from orders dated 15/7/2020 and the later order dated 19. What is the date of the later order? 19/4/2020. 15/7, earlier order 19/4 and the later order dated 15/7.
7/2021.
In the light of the fact that the petitioners have already instituted separate writ petitions. One writ petition or two?
Only one writ petition.
Both the person instituted a separate writ petition assailing the consequential order dated 31/5/2022 passed by the state of Punjab.
Yes, sir.
Passed by the state of Punjab, refusing to release their land from the ambit of imposition. The said order constitutes an independent cause of action, and it is for the petitioners to pursue their remedies in relation to the same. The special petitions are recommended dismissed.
Has to be heard, Millards. Your Lordship said earlier, put it on the notice.
Rishipal is now presented by counsel. You don't need to file a counter or anything.
All the records are already here.
All the records are here. So it has to be heard.
Lordship may grant leave in the hearing.
Yes. Leave granted. List for hearing. Trial court records have been received.
Trial court records is not been called. It will not be summoned. They or transit it will be called.
You said records are already here?
No, whatever is relevant in terms of the witnesses I have.
Registry shall requisition the trial court records and undertake translation of documents in vernacular, if any. Copies of the record shall be furnished to the counsel appearing for the parties. This for hearing on 12th November. After this, sir.
Statement got passed over in this matter.
You are appearing for whom?
The state. Lordship, I am led.
For the state.
Lordship, I am led by Learned Archana Bhattacharya. Is held up before another court.
Anyone is appearing for Ardu? How did you serve it?
Milords, in fact, as per the last order, Milords, the state was his surveil. I have served him through counsel also, who was representing him before the trial court, before the appellate court. But they choose not to appear. In fact, if Milords will have my affidavit, they had themselves furnished the address. I had served him at that address, which says that no such person.
The office report still continues to show him as unserved.
Yes, please, Milords.
Then what are we to do? We can't accept your dusty service upon the learned counsel, but we did not permit you to
last
order counsel.
Last order.
Carry out certain corrections when it comes before the appellate court. We said that you need to effect service on the person himself.
Milords, so my service affidavit is there, Milords. He had furnished the respondent is appearing.
File an application for substitution.
I'll do that.
As per the office report dated 3/9/2025, respondent number 2 still remains unserved. And counsel for the petitioner seeks some time to take necessary steps in relation to based on
Lordship, on last day, state was requested to. So we tried and the address was.
There's nobody there.
Nobody.
Let him take steps. You can file those.
Lords, I received respondent number 2, counter affidavit at 4 p.m. So, my lords, can I
File a rejoinder.
Yes.
And counsel for the petitioner seeks some time to file a rejoinder to the counter affidavit filed by respondent number 2. It shall be done well before the next stage of hearing based on 3rd November. 33. 33.
Let him say whether
Milord, Lord, I was granted, my lord, I filed a discharge application, a revision against the discharge, my lord.
Been filed. Received it?
Please, my lord. Para 5.1.
To that. Counter affidavit speaks quite strongly against the
My
petition.
lord, I am not on the merits of the case.
Then?
Kindly appreciate that. I am not on the merits. I am saying the High Court granted me liberty that you go and file a revision petition in the Sessions Court. My lord, till the time I filed it, my lord, only on the third day.
Application instead of appearing there.
My lord, this is on a very limited point. The court has not gone into the merits of the case.
Was dismissed as withdrawn with liberty to go before the Sessions Court.
Sessions Court, yes, my lords.
There you file an adjournment application.
I filed, my lord, on 21st. This happened. The dates are important, my lord. This happened on 18/11/24. I immediately moved, my lord, to the trial court, my lord, that this is a liberty granted by the High Court to move for a discharge application before the Sessions Court, my lord. On 21st, I filed an application. Kindly grant me some time.
On 18th November 2024.
Please, my lords.
When did the ACJM frame?
21st of November, my lord, before I file, I got this order on 19th. I immediately moved to the trial court, my lord, that please grant me some time so that I may file a revision. There is a liberty granted by the High Court. And my lord, thereafter, and no 207 compliance, even till then, my lord, till now.
You said anything in your counter about these dates, though?
My lord, please see the reason for delay in the counter is page 8.
Page 10, my lords.
Page 8, my lord, is the table.
Yes,
Page
my
8
lord.
is the table. Why there was a delay, my lord? Please see para 16, they have said so.
Rejected the discharge application.
Yes, my lord. Para 16, my lords, at page 8 of their counter. Now, please see why it got adjourned, matter adjourned. Thereafter, the IO was not remaining present. There were bailable warrants against the IO. And, my lord, and thereafter, my lord, he did not remain present. And ultimately, my lord, I filed a revision application. 207 compliance is not there.
Lords, those dates may not be relevant, my lords. The dates which appear on page 10 would be relevant, my lords, because the cause of action.
My lord, what today I am requesting that I may be allowed
to say what he has to say, thereafter we come back.
Please, my lord. Grateful, man. My lord, what I am today requesting.
We will hear the State's Counsel.
Very well.
Yes, my lords.
I'm sorry.
My lords, the dates at page number 10 would be relevant because from there the cause of action arises, my lords. 18/11/2024, my lords.
Yes.
My lord, discharge application was rejected on 7/2024, my lords. 18/11, the APP submitted an undertaking stating that accused number 2 shall remain present on the next scheduled date, fixed for framing of charges. Accused number 1 was not present. My lord, there is a deliberate delay in the matter, my lords. They are using these proceedings to delay the trial. That's the simple reason for all these applications, my lords. Thereafter, my lords, in November 2024, accused number 1 and 2 submitted applications before the trial court requesting that charges not be framed, my lords. Additionally, they filed an application seeking production of their further evidence. Both applications were dismissed, my lords. My lords, learned trial court came to a definite conclusion that the attempt on behalf of the accused was to protract the trial, my lords. Their discharge applications were already dismissed, my lords. So only because of the delay which was deliberately caused by the accused, their applications were dismissed, my lords.
Yes. What do you have to say now? Your discharge application was dismissed on 15th July itself.
My lord, thereafter, I filed an application before the High Court. Kindly see the order at page 116.
116.
116, my lord.
Yes.
The High Court said you have directly filed it here, though it is a concurrent jurisdiction. High Court granted me liberty to go to the Sessions Court by way of filing a revision application. Learned advocate seeks permission to withdraw the present with a view to approach before the Learned Sessions Court by filing an appropriate application. Permission is prayed for as granted. The application stands disposed of as withdrawn. It is clarified to this that this
before the High Court was filed against the dismissal of your discharge application.
My lord, yes, my lord. It was before the High Court. Then the High Court said that you go before the Sessions Court. It is having a concurrent jurisdiction, my lord, under 397. My lord, my lord, this order is on 18/11. We got, my lord, this order on 1911. On 21st, my lord, we immediately moved to the trial court that we are in the process of filing a revision application, and this is the liberty granted to us by the High Court. So, my lord, on 21st, we moved two applications, my lord. One that kindly adjourn with a view that we may be able to file the revision application before the Sessions Court, and two, my lord, that please send supply us certain documents to follow 207.
For the High Court, it's not as if there was a direction or something of that sort. You withdrew the
My lord, I withdrew because the High Court was the opinion, my lord, that my lord, you, though concurrent jurisdiction, and my lord, there is a precedent in the state of Gujarat. My lord, I'll just tell, my lord, what was the reason. There is a
that I took liberty in November, therefore the trial court has to wait till I file a revision at my own convenience.
No, my lord. Kindly see, my lord, on the very next day I went. On 21st, the charge is framed. On 21st of November, what today I am requesting, my lord, that I may be allowed to, my lord, file my revision before the concerned court, my lord, the Sessions Court, in view of the liberty.
I'm grateful, my lord. Extremely grateful.
And already filed, my lord. We have filed the revision petition, my lord, before the Sessions Court.
The CNR case.
My lord, may my lord be allowed to withdraw, my lord.
We record after hearing the counsel for the petitioner because this order might be misrepresented before the trial court.
We normally mention that the counsel, having argued for some time, seeks permission to withdraw.
Grateful, my lord. I'm extremely grateful.
The inference from that can be drawn by.
Please, my lord. Grateful, my lord. Grateful.
Permission to withdraw the special petition. Permission grant the special petition.
Great.
It's according to dismissal.
Grateful, my lord.
My lords, I'm appearing for the state, your lordships. I'm seeking some time to file counter. However, respondent 2 is not served as per office report. Respondent 1 is not served.
One is not served.
Yeah, sorry, incomplete for 2, your lordships. That is in transit laws. We have taken the steps.
As per the office report dated P9/2025, the tracking report in relation to respondent number 2 is still available. This after proof of such services, etc. is received. Interim order dated 19/5/2025. You have to ask for extension of the interim order. We have to do it on our own. Yes.
35.
Service is incomplete in this one. But is the matter going on at least?
No, my lord.
Why it's part of our clarification?
My lords may kindly see the compilation of orders which have got.
mandatory compilation. The Lordships at page number 1, your Lordships order, my Lords. 19.5, your Lordships have said that High Court should not want to pass the order. Lordship may kindly come to page 14, my Lords. Despite your Lordship's order, High Court again extends its interim order, my Lords.
But what is the magistrate doing?
My Lords, magistrate orders have also compiled. At page 3, it records your Lordship's order, my Lords. You have filed your Lordship's order. Thereafter, the accused is absent on all the dates.
Accused are directed to appear before this court.
Correct.
They are not appearing.
No, my Lords. My Lords may kindly see from page 5 onwards, my Lords. A1, A5 absent.
You are appearing for whom?
Statement.
For the state.
Page 5 absent, my Lords. Page 6, all accused absent. Again, page 7, A1, A2, A5 absent.
They are all on bail, is it?
41A notice was served to them, my Lords. They don't appear. That's why the trial court has issued non-bailable warrants, my Lords, against which, after dismissal of the quash, they filed criminal petitions.
And where is the order of the learned judge again?
My Lords, page 14, my Lords. At page 15, both the
being informed of the order passed by this court.
We have informed your Lordship's order, my Lords. Then
difficulty is without service being complete, we can't satisfy the order.
I understand, my Lords. I understand. The only intelligence which I am seeking is we have also served through the seat. The counsel refused to take. They are not at their present address. They are not appearing before the trial court.
Final application, effect substituted service, they can't get away from it.
But Lordships, my Lords,
we can't proceed
no,
the matter.
my Lords, I'm not asking for that, my Lords. I'm only asking, let the trial court may take it up day by day, my Lords, or at least week by week, my Lords. Because long dates are being given, my Lords.
The trial court also has to arrange its board, is it not? Yours is not the only case before it.
My Lord, since 20 it is pending, my Lords.
File an application, do the needful here so that this order can be examined on merits. As per the office report dated 3/9/2025. Respondents 2 and 3 still remain unserved. Necessary steps shall be taken by the counsel for the petition. The earlier interim order dated. Earlier order dated 19/5/2025 passed by this court is reiterated, and the learned 12th Roman clerk, additional chief metropolitan magistrate HON'BLE Telangana, is requested to proceed with the matter. In the light of the earlier direction of the High Court to dispose it of within 1 minute.
Grateful members.
Lordship notices there's a letter circulated by the state seeking a few weeks for the counter.
And then counsel appearing for the respondent seeks time to file a counter affidavit. Usual order. List on 10th.
Please, Your Lordships, in this matter, there has been a change of counsel for the petitioner. We have filed a wakalatnama along with the NOC yesterday itself and seeking some time to complete the proceedings in this matter.
You must not accept a brief which is already listed unless you're in a position to burn some midnight oil and get ready. You can't say that I just took the brief today morning, matter is listed today. I'm entitled as of right to an adjournment. You are not. If you take the brief midway like this, knowing fully well that it is already listed, then it's for you to get prepared with the matter.
Even at the last occasion, they took adjournment on the same ground itself in July. My Lordship may have that order.
July also,
Please, Your Lordship.
that counsel is
Same
briefed
ground.
again, is it?
No, it's the same, I think.
Same counsel.
I have no idea, but.
He's saying he entered appearance yesterday.
22/7, the order reads as, okay, that adjournment.
What is the date?
22/7. They have an interim order in their favor. It's a government land, it's a lake that is there.
The registry also selectively places the ROPs before us.
My Lordship.
22/7 is not there.
My Lordship may have a look at this order.
ROPs are not.
Today's office report reads that, Your Lordship. My Lordship may have a look at today's office report.
Your Lordships, in this
Change of counsel. What is the name of the counsel?
Your Lordships, this is for Lex Regis Law Office.
Who is the counsel who has now stepped into the matter? You said yesterday some new counsel.
Yes, Your Lordship, yes, Your Lordship.
What is his name?
For Lex Regis Law Office is Your Lordship, is the AO. A wakalat was filed yesterday along with the NC, Your Lordship.
And who was the counsel who stepped in October then?
So that name is not reflects to previous on.
Your Lordship, it was Mr. Amarjeet Singh.
We'll vacate the order and then.
Your Lordship, in that case, short passover may be granted.
You can't buy time like this and say that each time the matter comes up, I'll engage a new counsel.
Your Lordship, will argue if a passover is granted in this case.
Passover.
Deeply obliged, Your Lordship.
But I appear in 38.5.
38, perhaps we'll need to give you a date. Matter was listed today with the understanding that it would be taken up in the afternoon session. But this is not the regular bench. This may not be over within 2 hours. And it's better that we give you another.
One thing, if I may point one,
Lordship, I am appearing in 38.1, 2, 3, and 4, my lord.
So in 38.1, I am
We'll give you a date.
There's one point I have. In my case, my case is different from all other cases. There is a delay of 458 days in filing.
38, there's 48.
8408 of 2025. And the quantum involved is 38 lakh, whereas the national tax policy, litigation policy.
We are more concerned with the principle there.
But I completely bow down. It's only humble submission.
We'll decide the issue. If the issue is decided in your favor, we don't even need to go into the litigation.
One aspect, if I may point out, in 38.5, with my lord's permission, one of the matters is below the threshold limit. That anyways they can't file in the
threshold limit also, you must show us the circular. If it is a matter which is of recurrent nature, normally the circular makes exception.
Here it is not. In fact, it says, Your Lordships, it is a clarification to the contrary, my lord. My lord may have this.
Do you have a copy of the circular?
I have, and it
There no
says,
exception.
No, rather it says that every assessee's case is to be separately dealt with, even if it was decided
Apart from that, it will also have an exception with regard to questions of law which come up frequently.
I'm grateful, my lord, but it is not there. If my lord may have page 7, para 4, my lord. Page 7, my lords have it, my lord?
Now, we are not dealing with the validity of the provision.
No, we are not.
Basically, the interpretation of
Yes, with regard to 28, Your Lordship, with regard to limitation. That's right. One point, Your Lordship, was these all are pre-adjudication matters.
Page 7, my lord.
Though notices were issued, it has to be dealt with in view of canon judgment, which has already been.
File a reply.
This for hearing not.
But in these cases, 12 years, my lord. In my case, my lord, 12 years. They did not adjudicate. That's the issue which my lords are concerned.
They have something, what is that? Call book.
My lord, that call book was after 8 years in some cases, my lord. They are relying upon a call book after 8 years, my lord. And the law says 1 year is the period of adjudication. Only 1 year, my lord. So, my lord, they are actually, my lord. Anyways, my lord, we'll argue it next time, my lord. We'll file a count.
6 October.
Great pleasure.
6 It needs to be completed in the meantime. Whoever wants to file whatever.
1 week after that.
Right, 6th October, not an auspicious name.
My lord, I'm sorry, my lord. I have some religious program till 5th, my lord. I'll have to prepare also to.
13.
I'm great. Extremely.
40. Number. Expected that respondent number 4 has passed away.
Passed away.
May be allowed to.
Is the answer of the respondent?
This is the
answer.
For
the petitioner states that respondent number 4 is no more and seeks time to take necessary steps. Based on what do you have to say?
For respondent number 5, kindly grant me 4 weeks time to file the counter.
One counsel for appearing for respondent number 5 may file the counter referral in the meanwhile. Based on for the next year, based on 27.
So there is one more development that petitioner, we need to delete petitioner number 2 and 8 because one have passed away, 8 has passed away issueless, and
you filed an application for some other respondents.
I filed an application for respondent, deletion of respondents.
That has been ordered already.
They have been deleted.
They
Now
already deleted.
I now need to file deletion of.
File an application. File an.
I'll do. Like.
Yes.
We beg to have an objection regarding maintainability as well.
Lord, appearing.
41.
My lord,
Objection regarding maintainability as
Service is incomplete. Notice has already been ordered.
yes, my lord, notice was some time ago. And my lord, pleadings are now complete as far as this.
Someone is yet to be served.
My lord, there are some other.
Complete. Why did I?
Seems as for the office report service is complete.
Seems to be. Perhaps I did not see the latest.
So this will require little time. I had handed over a note on the last occasion if your lordship recall. If your lordships can keep it, yes, certainly. If your lordships can keep it on an NMD, my lords, we will.
NMD, what happens is you join the queue, and we already have about 70 or 80 matters. So
I have a problem.
It will take a little.
That is the reason why it's better to take it up on a miscellaneous day with the understanding, if it is possible, we will take it up in the afternoon session.
As you know.
I think that's.
Can you give me a copy of the book?
Yes, sir.
Yes.
Yes, for you. As service is stated to be complete. This is the matter for your on 6th October. Readings to be completed already complete, or anybody has to find?
Yes.
Readings may be completed.
Obliged.
Letter is there.
Modest continue.
When it comes to advocate on record, again, who is appearing for the advocate on record? Say more personal difficulty, without saying what the personal difficulty is. Registry has chosen to ignore our order, requiring them not to accept letters which do not disclose what the personal difficulty is.
But it does say that he's not keeping well, Your Lordship.
Then it doesn't say.
It does, Your Lordship. It's a reason for adjournment. Let's say on
Advocate on record for respondents 1 to 3 is in personal difficulty and therefore is seeking adjournment by 3 weeks. You have a different letter.
Please, Your Lordship, which reads as not.
Obviously, he shared it with you, but not with us. What does that letter say?
It says that he's not keeping well.
Not
Personal
keeping
difficulty is not keeping well and unable to speak.
Oh, perhaps exaggeration for you, or
My Lordship, now look at this one.
what is this new practice? Same letter is not being given to all concerned.
Point 4, Your Lordship.
Same Naveen Nagarjuna. Where is he? Naveen Nagarjuna.
Your Lordship, I am appearing for the respondents.
Yes, what is changed? One letter is given to us, a different letter is given to the counsel for the petitioner. The letter for adjournment is also being manipulated.
Your Lordship, AOR is not keeping well today.
Why you not said that in the letter which you've given us, but the letter which you've given to the other side?
So, revised letter will be given later to the.
Why are you not being truthful with us then?
Sorry, Lordship, you are not audible to me.
Very convenient. In the letter that you have circulated, which is placed before us, there is no mention of the fact that the AOR is unwell. You've said that in the letter given to the petitioner's counsel, but not in the letter given to the court.
Your Lordship.
Letters.
Your Lordship, we will submit the revised letter later. The
Yeah.
registry raised some objections.
Madam, we are not asking you for your future course of action. What is your explanation for giving different letters like this? We find.
We gave the letter later because the registry raised an objection.
Letter circulated, letter for adjournment circulated by the Learned Counsel for respondent numbers 1 to 3, that the only reason for seeking adjournment was stated to be the personal difficulty faced by the said Learned Counsel. However, the very same Learned Counsel furnished a letter for adjournment to the Learned Senior Counsel appearing for the petitioner, wherein he stated that the personal difficulty that is being faced is that he is not keeping well and is unable to speak also. Laryngitis in this season. He is unable to speak. Full stop. We have already passed orders to the effect that the registry should not accept letters for adjournment which do not disclose the reason for personal difficulty in explicit terms. We now find that the learned counsel are filing different letters, supplying different letters to the court and to the learned counsel appearing on the opposite side. The registry may be mindful of this aspect and shall insist on full reasons being given for seeking an adjournment in the letter of adjournment. Accepting the request of the learned counsel for the respondents, the matter is adjourned. List on 8 December, interim stay granted on 28/7/2025 shall continue to operate till the next meeting.
What is it?
43.
Is it lectures? Minutes, I'm waiting for this whole respondent minutes.
You need to file a counter. Learned counsel appearing for the respondent seeks some time to file
It's
a
2
counter.
weeks and the lodges will list it
Usual
there.
order. List on 27th October. Interim order dated 9/5/2025 shall continue to operate till the next meeting. 44, there's a letter.
No, but there is something that I need to do.
Sudden illness of the AOR.
No, but that apart, that is for respondent. But as a petitioner, we have to take some steps. One has died.
Who has died?
Respondent number 3.
3 died, is it?
And number 1, the address perhaps we'll have to check and take steps.
Effect service.
Lordship may grant us.
Service of notice. 3, you have to take steps.
And your lordships are granted the order of status quo till today, which may be continued.
Learned counsel appearing for respondent numbers 2, 4, 5, and 6. 6 in adjournment, by way of a letter on the ground of sudden illness. Because the case was listed, he fell in. So, sudden illness. Learned counsel for the petitioner states that respondent number 3 is no more and seeks time to take necessary steps. Further, he seeks time to effect service of notice afresh upon unserved. Is it? He's shown as unserved. Unserved respondent number 1.
Change in address.
Service number 1.
Office report says that
Yes, service is not done.
address 11 without instruction.
Necessary steps shall be taken in that regard. Earlier interim order, earlier order of status dated 16/5/2025 shall continue to operate for the next meeting. List on 24th November.
45.
Lordship, I
This
know.
also perhaps is a matter that we'll have to hear, but we'll take it up on Monday.
I am the original owner of this.
You
I am
are the owner.
I'm not.
That's
But
You are represented by counsel, then please ask.
My respondent, I'm not impeded here.
Sorry?
I'm not impeded here at all. I'm not impeded, my lord. I'm seeking impediment.
You are not.
I'm appealing for Mr. Dar. My objections have been withstood.
my lords.
That's the father.
Yes.
Father's application has already been dismissed. There's no question been pleading you now.
No, that is what I need to bring.
Your father's application was dismissed as infructuous by the High Court on 28/1/2025.
The lordship on said.
That order has attained finality.
Yes, my lords.
Lordship on said.
Anyway, we'll consider the matter on Monday.
My lords.
My lord, kindly allow me to see pleaded.
No question.
My lords, let me make a submission.
There is a question of the father of this lady coming up with his ownership. We are taking it up on Monday, counsel.
Let me make a submission. I filed a convenience compilation today in the morning, subject because some documents were provided.
This is a decree of 2021.
22, my lords.
22.
Please, my lords.
And what has happened?
They are employing this strategy since last 3 years, my lords.
My lords.
They're doing it here also, for the Honorable Supreme Court also.
My lord, my colleague may let me make a submission. The father.
You are a legal aid counsel.
I'm a legal aid.
Be aware of the scope of such appearance. You do not need to identify the client with the client to such an extent that you forget the fact that you are the officer of the court in the first instance.
That is why there are objections by the.
We'll test that on Monday.
My lord, may then have it on Tuesday because he may be required to hear this.
We will take it up in the afternoon.
Okay, my lord.
List on, you must say all right or very well. Okay, not important.
I understand. Apologies, my lord.
A, list on A, with the understanding that the matter would be taken up for hearing within the afternoon session.
Obliged. Obliged.
What is it?
May I please, lord?
This also is a hearing matter.
Yes, my lord. It will take some time.
May please, my lords, may I make just a small housekeeping submissions?
Yes.
Please, my lords. My lords, I actually submit this every time, but I also filed a letter in the registry. Inadvertently, at the time of submission of Wakalatnama, I mentioned R2 and R3. I am actually have instructions only to appear for R3 and the counter is also filed only for R3. But every time now in the office report, this is flagged. So I just want, my lords.
Service is complete.
My lords, R2 is an officer of the state, so there's no prejudice caused. I don't have instructions to appear for.
You need to appear for him. As long as he's served and he doesn't choose to come,
Yes, if my lords may make that clerical correction, my lords, because otherwise every time in the office report, my lords, it appears that, and my submission doesn't come on record anywhere, although I make it every time.
Mr. Ritesh Kumar has filed a Wakalatnama on behalf of R2 and 3, is what is stated.
Yes, I filed a letter in the registry also on 31st January 2024 explaining that this was an inadvertent mention of R2, that we are only for R3.
In the Wakalat also there is no signature of R2. Only R3 signature is there.
Yes, my lords.
Stated that the then counsel appearing for respondent number 3 inadvertently mentioned the name of respondent number 2 also, but the said Wakalatnama was not signed by respondent number 2. We find that service of notice is complete and respondent number 2 has not chosen to engage independent legal counsel. The registry may therefore take note of the fact that the then counsel hearing for respondent number 3 is not a hearing for respondent number 2. List for hearing on 27th October.
Very well.
Extremely grateful, my lords. Extremely grateful.
47. This is a joint application.
Application is fine. Only cases to be quashed, is it?
Quashed and
no money exchange in hands.
I have brought the bankruptcy.
There's no mention of any.
There is in condition number 3B, my lord, at page 10.
Oh, I missed it. How much would you be paying? 15
lakh. And I have brought bank drafts, demand drafts, table at Mumbai. These are the photocopies of this. And
you will
I
be
am
handing over
to the petitioner.
The parties are also present on
Yes,
that?
Lord. Yeah.
Oh, the parties are both.
Yes, my lord. And this is photocopy for
Both of you understand English, Hindi?
Yes, my lord.
English? Both of you are agreeable to this? You have signed this agreement voluntarily? You want the marriage to be dissolved? Petition was filed seeking transfer of a pending case. The parties were referred to the Supreme Court Mediation Center to explore the possibility of settlement of their differences. Pursuant thereto, the parties compromised their differences and executed settlement agreement dated 22/8/2025. In terms thereof, they have filed a joint application seeking appropriate directions in IA number 201056/2025. We find that though the parties got married on 7/5/2019, they have been staying separate since October 2021. They have no children. 2 cases are stated to be pending. 2 cases, if not?
Yes, my lord.
2 cases are stated to be pending between them.
Page number 10, Your Lordship.
The page number 10.
10.
Page number 10.
In the IA.
And case number noted in prayer clause at page 4.
Namely, HMA number 280 of 2024, titled Gaurav HON'BLE versus Deepika Kaur, pending before the learned Principal Judge, Family Court, Shimla, Himachal Pradesh, and domestic violence cases in CNR number so and so. This is at page 3 of the pending before so and so. In the light of the settlement of the matrimonial dispute filed between the parties, we find no reason to prolong their marital relationship or keep the litigation initiated by them pending. We accordingly exercise our jurisdiction in the Article 140 Constitution of India and resolve the marriage of buying between the parties on 7/5/2019. In terms of the settlement agreement, therefore, to super, the then counsel for the responding husbands handed over to demand drafts. Give the details. Or the sum of rupees 15 lakh, within that is mentioned the details. To be done counsel for the petition. It's given to the party.
Yes.
Hand it over to the party.
Yes.
Give it to the not to some.
Check it.
Give it to the petition, right? Mention that also both the parties are present in person for this. And state that they want to be interviewed with the separation and are desirous of raising the marriage. Pending cases in so and so for stand wash. We are watching the cases. There's no need for you to withdraw them.
I'm very grateful.
Again, you'll come back saying that it's not washed and they're not withdrawn or something. That happened earlier in one other.
Suppose we send these orders to our counsel there, they may not present it or whatever, for whatever reason.
The counsel petition is disposed of. Please shall draw up a decree of resolution of marriage. In terms of this.
So kindly pass the divorce to.
Yes.
That's why I'm seeking to file parents.
I'm very grateful.
Yes.
I'm very grateful.
Yeah.
48. That is 48 years here. Petitioner is the women millers. All have been granted bail.
She is supposed to go nearly a year. Unless they come forward and say that she has passed years before. It's according to the order. The ASG dismissed the first of CCTV footage also. That's what she did.
Please
be order notice.
Give it to a tenable millers. She plus 9 sections slapped millers. What? A consensual relationship millers. And 437 is come.
You are supposed to be extorting.
No, not
the threat of a rape.
Plus all granted. All have been.
Let us see. We'll check your bona fides once the state comes and tells us what exactly your past antecedents are.
What should I give a returnable
Returnable on
short date millers.
6th October. Service shall be affected by all modes including just.
Standing counsel also.
Permission is granted to effect service of notice upon the standing of the designated counsel for the state of
UP millers.
UP.
Yes. Obliged. Grateful.
50.
Senior sort pass over. Last one.
51. Item 50 million, I beg to appear for the petitioner, my lord. Only one infirmity I wish to show directly on the point. My lords may have para 28 of the impugn order. 28 of the impugn order at page number 11, bottom of the page.
Yes.
My lords, the Honorable High Court, in fact, categorically records that no finding has been recorded therein. That is the order passed by the collector regarding any fraud claimed by the lotteries. Rather, the duties have been cancelled on the grounds.
Beside that aspect, a 1994 order, you seek to challenge it in 2015.
Oh, yes, 14. Now, why? Because
15.
Because my
And in the meanwhile, grant of Bhumidari rights takes place in 2006, which is never challenged.
But my lord, that is what the collector.
You can't just wake up at your own convenience after decades.
I'll explain why, my lord, because that.
And then say, I want to challenge the allotment.
The collector has discussed that as to what is the implication of the transfer of Bhumidari right. In fact, my lord may have that finding. I'll in fact take my lord directly to that finding. My lord may have page.
The delay on your part is sufficient to initiate the entire proceeding.
My lord continued in possession. Only two findings that I'll rest my case, my lord, with the wisdom of the court. Only two findings, my lord. My lords may have page 231 because I wish to address directly what is falling from my bench, from the bench. 231, which is the order passed by the collector, my lord.
Yes.
He discusses the now, my lord, if I may read fifth line from the top. On 10/11/2006 has been deliberately declared non-agricultural. This is what is the transfer of Bhumidari rights. Out of the total 11 lotteries, 7 lotteries are from Charter Scheduled Caste Committee, 4 lotteries are from Barber. As per the rules, the lotteries of SC can't sell the lotted land without permission of the DA. Therefore, as soon as they became transferable landowners, they immediately got the land declared non-agricultural so that there is no need to take permission. This makes it clear that this allotment has been made to ineligible persons under a well-planned conspiracy. So, what? In fact, there are findings of fraud even before in the order. A lot of findings of fraud there.
Will they conclude? Issue notice, returnable on.
I'm grateful for that. It's
17 November, so we should be effective by almost.
Please, ma'am. One of those Bengal matters, this is by the physically
You claim to be
physically
selected and appointed candidates.
Untainted,
Selected,
working.
And why are you championing the cause of tainted candidates?
No, not tainted.
You challenged the judgment dated 10/7/2025.
My petition was dismissed relying upon that order.
10/7/2025 is in relation to tainted candidates.
We are not concerned with that.
So you are now challenging that judgment.
Because I'm
obviously you are championing their cause.
Not at all.
In any event, there's nothing new that you have raised. We have already entertained sufficient SLPs.
Let me hear me for a moment. Page 1, see, my writ petition was dismissed relying upon the other.
Whatever it is, you have already seized of sufficient matters. We don't need to multiply petitions.
This is entirely different.
There's nothing new that we have raised.
Page B.
Every aspect that you have raised. Tell us one aspect that is not being considered by us.
This is exclusively by physical.
One aspect.
Yes. This is exclusively by physically handicapped.
That doesn't matter. No, whether they are physically handicapped or whether they're regular people,
because
candidates,
the seats,
it makes no difference.
The seats allotted to the physically handicapped in 2016 have been virtually halved in 2025. And
that aspect also we've already kept it open.
No, the other
in the event any person who was selected and appointed to a particular post is able to show us that he has not been appointed after the fresh selection because of reduction in the number of vacancies in that particular category, then we'll interfere.
This is that issue.
That is not there. You don't even give details.
But it's that page.
Where are the details?
Page B.
These people.
Page B.
17 people.
Page B.
Where do we find the details of which posts they have been appointed to?
Page B. For a moment.
Show us those details, please. Which posts were these 17?
They belong to the physically handicapped.
Which posts were they appointed to? None of you hear what we say. Is it?
No, we do.
You don't listen then. You hear, but you don't listen.
It's not
because we keep on asking the same question and we never get an answer.
It's not on record.
That is exactly what we've already said. We do not allow cases to be built from stage to stage.
The other thing,
when you are specifically saying that we were appointed,
yes.
Now those posts are removed. Yes. Don't you think it's relevant for you to tell us which posts you were appointed to?
It was there before.
How many posts were notified in 2016? How many posts have been?
It's all there.
Where is all that?
Page B,
we don't have the details of which posts you were appointed to.
Page B,
which posts were you appointed to? Unless you are able to show us that.
In the visually
handicapped, build up an argument in air.
But in the visually handicapped category, in the hearing,
which posts were these 17
of class 9,
appointed
10,
to?
Class 9, 10,
which subjects?
For a different subject.
Where are they?
But that was
nothing. Sorry.
Well, that was in the chat.
Earlier order is there, as we have already entertained sufficient number of special petitions on the issues arising out of the fresh selection sought to be undertaken by the West Bengal Central School Service Commission. Central School.
This issue has not been raised in the petition.
To entertain this special leave petition, which basically raises the very same issues once again. The special leave petitions according to the But one judgment that he has filed, because you keep saying you're entering for the commission, perhaps the state.
Yes, madam.
That 10th July 25.
Tainted, they challenged it in the division.
Tainted candidates, the Advocate General of the state appears and says that our judgment, I'm a member to that, does not say anything about tainted candidates not being permitted to appear.
May I say that?
This is how the state is understanding the judgment. What kind of blue-eyed boys and girls are these that you go to the extent of getting the Advocate General to appear and advance this argument on behalf of these tainted candidates?
No, Maharaj, I appreciate that.
That initial inquiry, what happened? The CPI was supposed to look into the issue as to whether those high up in power were involved. What is happening on that, Ms.
No, that I think was set aside. I was not appearing in that batch of matters, but from what I know,
the later order that we had passed on,
supernumerary post.
No. With regard to supernumerary is one thing, but with regard to the CBI looking into the allegations
that
against.
was part of set aside that direction so far as I know, because I was not appearing in those batches.
That I can't remember because that was a later order. It was not part.
It was not part of the judgment.
May make one request.
But on the face of it, shocking.
They made it
shocking. I mean, to begin with, you ruin the lives of all these candidates by doing this, by bringing in your own candidates, manipulating OMRs, doing all this nonsense, and now you want those tainted candidates to be smuggled in again.
May I say that after my lord's orders, everybody has been removed.
When your state goes before the that judgment, I've asked them to keep a copy of that to be used in future.
But maybe
so I'll keep a copy of that judgment. Thank you for at least bringing that judgment to our notice.
May I make a request? We only keep it pending along with that. Because the issue of
we only need that judgment. You supplied it to us, we keep that. Your Excel.
The issue of disability has not been raised in any of the other petitions. I have filed all of those. Because these are their disability has increased. Lot of them,
whatever it is, there's no question.
That is not raised in any of the other petitions. Only keep it tagged along with it.
Defect Paria we've already entertained, so there's no new issue that we are not going to multiply
the protection which was granted on
that order applies to all. It is not limited to the petitioners.
Unfortunately, they are saying because they have not been informed by the
all kinds of statements. There was a
2nd September was the last date. All candidates were permitted to be entertained. All those who were appointed and continuing.
Passed a subsequent order asking them that they could apply offline.
These are ST millers and they have not been granted the age relaxation.
If you have not taken advantage of the orders that we had passed, giving you sufficient time, then we can't do.
Because
it can't be extended ad nauseam.
In some form, millers, they are all untainted candidates. They have been there.
Same order.
That's my name may be recorded in the appearance in 52.
52 for the commission.
Yes.
54. Yes.
I exerted why the mother-in-law.
Now the divorce decree stands as on date.
Yes, no, but that
You don't have a stay order.
no, the stay is not there, but my appeal is pending. Lordship
It is pending. Your domestic relationship has ended.
Lordship, Lordship, it is
Is there any judgment
Yes.
that holds to that?
Yes, sir.
That after the divorce also you continue to have a domestic?
Yes.
Where is that?
Paragraph 59.2.
Did you not cite it?
Yes,
to the High Court?
He's made a note of the judgment, but doesn't consider 59.2.
Which para of this judgment?
59.2.
59.
Page 52.
Yes.
59.2, subclause 2 and subclause 4. In the event of a divorce, the marriage would no longer be subsisting, but if a woman wife is subjected to any domestic violence either during marriage or even subsequent to a
Your
divorce.
DVC is also dismissed.
DVC was dismissed on grounds of limited.
Whatever it is, it's dismissed. There's no DVC there.
But my lords, then again, the court also recognizes that therefore, even when the marital ties cease, 59.4, 59.24, and there is no subsisting domestic relationship, next page.
Yes. Between the aggrieved woman and the respondent, the acts of domestic violence are related to the period of domestic relationship. But here there's no DVC.
No, Lordship may also now have 26 of the Domestic Violence Act.
Shared household.
No, 26 is not shared household. 26 is that I can take up defenses under the Domestic Violence Act before a civil court. Lordship,
but this judgment doesn't really help you.
Well, it says that
the judgment has been considered in fact.
In fact, I placed it on the record. He doesn't consider 59.2.
But once you don't have a civil relation from divorce, you're not a wife, you're not in a domestic.
No, I continue.
Even this judgment which you are referring to,
yes,
it begins by saying that.
Yes.
Marriage is also a lifelong relationship unless a separation by a decree of divorce is ordered by a competent authority.
Yes.
Therefore, the decree of divorce is there in the your appeal is pending, but there's no stay order.
Finality is what the court has also taken. Lordship, we just have 15 for a moment. May I have another judgment?
He can't get remarried.
That
is all. So there's no other issue. It doesn't endure, it doesn't prolong the relationship.
I just have two aspects. One is the existence of domestic relationship, which is not, in my respectful submission, subject to a decree for divorce because the appeal has not attained finality or the decree.
That doesn't help you.
No difficulty. The second aspect is collusion, which Lordship may just have for a moment. The suit was filed by the mother-in-law. The mother-in-law passes away during the subsistence of the suit. Just have page 100 and 104 for a moment. Because the husband would have inherited rights in respect to.
Where is the brother of this lady?
He is residing separately in a 200 square yard in Delhi, in Karol Bagh. He is working in the UK embassy. Lordship may just have page 100.
Yes.
And whereas this is a relinquishment deed which is executed by my husband. And whereas Srimati Swaran Kaur died intestate on 4th of May 2016, leaving behind the following legal heirs. 49 years.
There's a will.
Yes. So first he executes a relinquishment deed, but when the mother passes away, a will is unregistered will is introduced before the court.
This document?
Lordship, this is a registered relinquishment deed dated 1st November 2016 at page 9.
And the will is dated 2013.
Will is dated 2013.
That's registered or
unregistered? It was only introduced before the court so as to show that the husband has no rights.
Presently residing in
Yes, I'm residing here from 1999. From the date of my marriage, I'm residing over here.
1999, the property stood in whose name?
My mother-in-law.
No. The mother-in-law's sale deed comes in 2011.
Mother-in-law's conveyance, they were all realized that in Delhi, a lot of properties were sold on agreement to sell basis. It was perhaps regularized in 2011 by way of a conveyance. It was the mother-in-law who was the
agreement of sale holder. Agreement of sale from?
From a third party.
Third party, not a DDA or something.
No. In fact, I got married. I have been living over here I have a child out of the marriage. My husband moves out in 2004.
Not this sister also. She's living there?
Separately, no. Not in this property.
She doesn't. She
She's
doesn't.
never resided after marriage. She's never resided over here.
She lives in Delhi?
Yes, sir. She lives in Rohini in another sector 13 apartment, which is slightly better than what. This is a 26-meter accommodation. I'm residing with my son.
We find perusal of the material based on record reflects that the husband of the petitioner, the former husband of the petitioner. So, former husband of the petitioner, what is his name? Nanak Mehta. Nanak Mehta executed, this is a registered document.
This is a registered document.
Executed a registered deed of relinquishment on 1/11/2016, where it is stated that the mother, Swaran Kaur, had died intestate on 4/5/2016. However, respondent number 1, Pratibha Chadda, the sister of Nanak Mehta, thereafter produced an unregistered will dated 27/2013, which is said to have been executed in her favor by Swaran Kaur. The contradiction in these documents requires examination. Issue notice, return the loan.
8th of September, I have been granted protection till 8th of September.
Return the loan 10th November. In the meanwhile, status quo obtaining as on date with regard to the possession of the property in question shall continue. That is, the petitioner shall not be evicted therefrom.
Absolutely.
In the next date of hearing.
Physics.
56.
It's a,
You've already rejected Arunima Paul is similar.
it's a mercy petition.
Where is Miss Devi? She's gone.
But please appreciate, after first SLT.
Sorry.
Just 2 minutes. I will not take more.
We've dealt with another matter.
I
also,
appreciate, just
where
for
there
my
were two people similar to you
yeah.
who had filed a writ petition in 2023 before the Calcutta High Court judgment. But unfortunately, after the writ petition was dismissed, they kept quiet. We can only offer you our sympathies. Beyond that, we can't.
Only one humble submission. Please appreciate.
You're overaged, you're overaged. The state has ruined the lives of many. We've already said that.
Today,
but there's nothing.
We are 40, we are qualified, but we are not committed. Subject.
You must have some other employment. It's not that you would not
I check. We are
twiddling your thumbs till the state comes up with some recruitment.
We are only 8 people. Subject to your lordship granting this limited.
We've already denied relief to
the reason being, we were
can't open this door. It can't be on the basis of those who have.
We had not troubled your
lordship. If we open the door, it will have to be for everybody who is identity.
That ought to have been, for the reason, 49.
Even when we were seized of the matter, you could have come forward.
But that's unfortunate.
You don't do that. You're all waiting in the wings, waiting for.
But we advise, that your filing writ petition was not the right record. May kindly, because the exams are. Only one order I am relying upon. Your lordship.
This application filed by the applicants. Miscellaneous applications according
to. Only one order which your lordships have passed on 21st order. Just have a look. Just have a look.
With regard to selected candidates.
No, your lordships granted
with regard to selected candidates because they were already given the benefit of
your lordships was
extension.
Extend till 31st. But exams have not yet started. That is scheduled.
This was already there. I
will test my
fate. We have not granted an order. This flowed from the concluding paragraphs of the judgment.
Agreed, I will test my fate. I only seek liberty to appear.
There is nothing.
Pass or 20.
Okay.
20.
The petitioners were the husband, mother-in-law, father-in-law convicted under section 304B. That is also within 7 months. The initial first statement given by
because you have good friends in the police department and you managed to browbeat the girl's father into giving that statement. That doesn't mean that you get away with it. Come to page 5 of the judgment, please. We don't even need to go by the interested witnesses' evidence. Look at what the doctor says. Paragraph 13 in the middle. Dr. M.A. Sattar. Please read it out.
Dr. M.A. Satar, PW6, had performed the post-mortem on the dead body of the deceased and found the ligature mark on her neck along with abrasions on her cheek and knee. According to this witness, the deceased had died due to asphyxia because of hanging. Abrasions found on the cheek and knee of the deceased further points out towards the fact that she was hanged by the accused persons, and while forcibly being hung, she has sustained these abrasions.
That is sufficient.
But these abrasions, this is not the kind of the evidence.
At least in some other cases, we find that the husband is kind enough to drug the wife before he hangs her. Here you hang her while she's alive and kicking, and she sustains those injuries trying to fight you while you are all hanging her.
May just this is not what PW6 says. This is inference. PW6 is only till this. According to this witness, this is a died due to asphyxia because of hanging. Thereafter, this is not what PW6 states. This is inference drawn by the High Court.
That is sufficient. Why did she have injuries on the rest of her body if she hanged herself?
The defense taken was she was being brought down.
Did I condone? However, we find no ground and reason to have the issue passed by the High Court, especially.
The FIR was after 11 days by the complainant himself.
Because you browbeat the father of the girl into giving a wrong statement.
But that state, 7 persons gave a statement.
Fortunately, the system at least did not get taken in by you.
7 persons gave that statement that it was
so.
society.
Sorry. Yes. 37. Counsel asked for a parcel. You are hearing?
Let's in this matter, a 5th respondent got impleaded, Millets, Brahat, Bangalore, Mahaparatana. And they have filed 70 pages.
All that.
Yes, please.
The order
yes,
of 2nd November 1995.
Yes, please.
The state's notification to enter the state's name in the property extract.
Yes.
And you filed a writ petition, and your writ petition was dismissed.
Yes.
And the finding is that you are in illegal possession of 3 acres.
May I submit, Millets?
So therefore, that has attained finality.
My last week, can appreciate one thing. 1943, 2 registered sale deeds, I have purchased the property.
This judgment has attained finality.
Indeed, Millets, my last week.
And we are now concerned with the very same 3 acres.
Your Lordship's Millets, that doesn't come, it's only a part of 3 acres out of 13
part
acres.
of the 3 acres.
3 acres, Millets, not that the thing. Millets, my lords, we can appreciate.
Once
the
the judgment attained finality,
Millets, what's been held, if I argue against myself, Millets, what's been held by the division benches, that to the extent of title determination, the revenue authorities have no power. That's been confirmed on the par with the.
In the light of the dismissal of that writ petition,
now,
which
Millets,
has
my lord,
attained finality,
Millets,
how do you even have a right to say anything contrary to what has been recorded there?
May I submit, Millets? 1943 onwards, I've been in possession of the property. I've got registered sale deeds.
There is now a finding of the High Court that you are in illegal possession of that.
I'm afraid, Millets, that was on the occasion when no evidence was produced before the learned single judge.
That judgment attained finality. We are not going to sit and appeal over that.
My lords, may can appreciate it's been held by the division bench as well. We are not getting into the title aspect as well. I've been in possession, I've been enjoying that one. Only plea that went against me was that, Millets, when in 1943 I purchased the property, my vendor did not describe how he got the title. That's all that's been there. Now, Millets, it's been said that I should go to the civil court. In fact, Millets, I had been in possession. I've got a presumption in my favor, both on account of registered sale and also. Millets, my lords, under identical circumstances, have held that it is the government which should go. They cannot take it to some. May I please that before your lordships, Millets, can you have a look at it? Just kindly have a look at it. Millets.
Actually, it's not true that they're in possession, Your Lordship. It's a lake.
Millets,
it's a lake.
Millets,
it's a lake that is.
It is not, Millets. 1943.
1939, my lordships have looked.
Millets, my kindly have a look at it, Millets. That's the judgment, Millets. I just read what's been relevant there. Millets, may kindly come to Millets. Millets. Para 8, my lords could see what's been said, and I'll see in the end what has happened. It seems to us, para 8 minutes. It seems to us clear from these provisions that the summary remedy for eviction, which is provided by Section 6 of the Act, this is Andhra Pradesh and Telangana Act of Encroachment, Millets, can be resorted to by the government only against persons who are in unauthorized occupation of any land which is the property of government. In regard to property described in subsection so also, there can be no doubt, difficulty or dispute as to the title of the government, and therefore, in respect of such property, the government would be free to take recourse to the summary remedy so and so. Millets, kindly come 10 lines down the line. If there is a bona fide dispute, I got the minutes, my lords got it up the inverted quotes there. If the government
What is the question of anything being said once there is a finding that you are in illegal possession, which is attained?
My lords may kindly come to page, para 10 minutes, para 10, my lords could see what's being said. It is the government which should go because I have been in possession based on original document.
You have a legitimate right, you would go to the civil court and assert it and
Minutes.
demonstrate it.
Minutes.
Obviously, you are fighting shy of it for
May I have that minute. I have only 2 planks to sustain myself. One is a registered document of 1943. It enjoys the presumption. And thereafterwards, until 1996, I had the mutation in my name and also my successors as well. The government did that one suo motu exercising power after 28 years. Could it be sustained? It should have been within reasonable time. If they have a rival claim, it is they who should be going. And what is the government they have in their favor? It's nothing except an authority to say that yes, we can come at any time. And that's why, your lordship said, observed in para 10, that if the government is the one, they can as well go, and they should succeed on the strength of whatever they claim. They cannot take recourse to and throw me out from 1943 minutes. And in fact, though it cannot be said, but I was asked in the corridor that I should be coming over here because.
Sorry?
I was brief just in the corridor I've got my handicaps
No. This one issue that we put to you, you really have no answer.
Kindly come to that judgment. Where the learned single judge, I'll take your lordship to that one. Kindly come to that one. My lords may kindly have it. At 169? Which is that one?
124.
That's at 120.
124 minutes. Kindly come to that one.
The type, I think that one gets to be better.
120?
There's a type copy.
Kindly come to 128 minutes. 1-page judgment where it's been said, we failed to provide any document or proof with regard to that one. At best, at best it could be with regard to 3 acres of land. Given their
You go to the civil court. This is not a matter of issue.
in fact, it is they who are going minutes.
Order. Having heard the counsel for the party and upon producing the material placed on record, we find that the issue decided against the petitioner by the court as
if I had only one sentence,
in 1995,
it was with a delay of 2 years,
and in consequence thereof, there is a clear finding that the petitioners are in illegal possession of at least 3 acres of land.
May I pray minutes?
Appearance is voluntary, which is judgment passed by the High Court. The specially petition referring to dismiss status quo order dated 3/2/2020 shall stand vacated.
May I pray for a small indulgence?
The liberty granted by the High Court to the petitioners to avail their remedies, if any, before the jurisdictional civil court is, however, reiterated.
The usual disclaimer, uninfluenced by any observation.
In the event they do so, the court may consider the case on merits and in accordance with law, uninfluenced by the dismissal of the specially petitioner.
Great.
And the observations made by the High Court in the included judgment.
Great.
Lordships will permit me to file physical appearance because my name is not yet on it.
Great.
50. Same learned judge who granted you the bail cancelled.
You also kindly consider.
Same learned judge.
Yes, yes, Lord. On what ground you are kindly consider or
you were granted bail